Okay, another one is good to go. That's right, just received our approvals. So now I can say it. This episode has been cleared for public release, but just barely. And that's all we needed. Welcome to the GovCon show. Today's topic, NDAs that no one reads. Now let me ask you something. Have you ever signed an NDA and had absolutely no idea what you just agreed to? I mean, not I just skimmed it or not I glanced at the first paragraph. I mean, you signed it and immediately moved on with your life. You just signed it and moved on. Yeah, you're not alone. I signed one last week that basically said I wouldn't disclose anything I might possibly learn in the universe, present or future. Yeah, that's impressive because I didn't even know we were working in the multiverse now. But that's the magic of modern NDAs. They attempt to protect information that hasn't been shared yet, might never be shared, and in some cases, probably shouldn't even exist. And somehow, we all just sign them anyway. So today, we're fixing that. Welcome to the GovCon show.
This broadcast has been cleared for public release, but just barely.
Broadcasting from deep inside the Federal Acquisition Labyrinth, this is the GovCon show. This show is for acquisition pros, wannabe pros, and procurement insiders who need a place to unpack the chaos. We speak fluent contracting and sarcasm. No clearance required. This is the GovCon show.
And away we go!
Welcome back to the GovCon show, where the far meets reality, and reality usually wins. I'm your host, Tim Magnuson, and today we're cracking open one of the most common and least understood documents in government contracting, the NDA. Now, I'm going to say this up front. I love this topic. Not casually, not academically. I mean, I've spent enough time in this space that I eventually sat down and wrote a book on it. 264 pages on NDAs. My book is entitled Become a Government Contracting Wizard, Mastering NDAs for Government Contractors. There's a copy on the shelf behind me here. Now, I wrote the book not because NDAs are exciting, but because they're dangerous when people think they understand them, and they don't. And that's the world we live in. NDAs are everywhere. Proposal teams, teaming partners, consultants, pre-RFP discussions, capture strategy meetings. Sometimes companies will send you an NDA before they even tell you what it is they want to talk about, which is basically saying, we need you to agree to protect something, but we're not ready to explain it to you yet. So that's comforting, but here's the reality. Most people would sign it. They've signed NDAs without reading them. And that means you've got professionals walking around with binding legal obligations that they've never actually processed. That's why this episode exists. Let's start with an uncomfortable truth here. A lot of NDAs, a lot of them are legal placebo, right? They look official, they feel serious, they're full of capital letters, but when you actually read them, you realize something. They're written so broadly that enforcement becomes questionable. And courts tend to notice that because courts don't like agreements that say things like, you may never disclose anything you learn from us for the rest of the time. Well, look at that. That is not a confidentiality agreement. That's just a legal fantasy novel, right? Courts are looking for reasonableness. And when your NDA says you may not disclose anything you learn ever, under any circumstances, that's not a confidentiality agreement. That is a control mechanism. And control mechanisms do not hold up well in court. But before we get into enforcement, we need to understand how these things actually show up. In government contracting, NDAs are everywhere. You'll see them when two companies explore teaming, or a consultant joins a proposal team, or maybe there's technical exchanges that start real early. And of course, there's always proprietary data that's getting shared. And in theory, that's good. NDAs are supposed to protect sensitive information. But in practice, a lot of them create confusion instead of offering clarity, because they're written to cover everything instead of what actually matters. If you work in government contracting very long, you've probably experienced this moment. You open your email and there it is, that NDA. You know, the one everybody on the program team has been expecting. Yeah, that one that you knew nothing about. So you open it, 12 pages long. Half the clauses reference laws that you've never heard of. And somewhere in there, you'll find that it says, receiving parties shall protect all disclosed information with the highest level of care under any applicable standard of commercial reasonableness. That sounds really impressive until you realize that there's nobody that you know of who knows what that actually means. So let's talk about some real clauses, because this is where things get ridiculous. One NDA I recently reviewed defined confidential information as anything related to business operations, ideas, or intentions. So basically everything. At that point, the NDA isn't protecting secrets, it's protecting existence, right? Another one said, if you're liable if you believe you have disclosed something, not if you did, if you think you might have disclosed something. Now, that's not enforcement. That's anxiety as a legal standard. And then there are the NDAs who say confidentiality must last into perpetuity, which means forever, longer than some civilizations. Now, courts tend to raise an eyebrow when confidentiality obligations last longer than civilization. Now, here's the important part. Not all NDAs are bad. In fact, good ones are critical. And a well-written NDA can be incredibly important. The key is understanding what they should actually do. A well-written NDA does three things. It defines what type of information is considered confidential and is warranted protections. Number two, it defines how long that information must be protected. And number three, it explains how that information must be protected, what the standards of care are. That's it. Clear, focused, enforceable. But many NDAs try to do something else. They try to control the information that doesn't belong to them. And this is something I've spent a lot of time breaking down in the book. And not from a legal theory perspective, but from what actually holds up in real world contracting environments. Because there's a big difference between language that sounds strong and language that is actually enforceable. Here's a classic issue. An NDA says, everything discussed is confidential. Well, okay. But what if you already knew that information? What if it was publicly available? What if it came from another source? Good NDAs address these issues with carve-outs. These carve-outs address the circumstances that are exempt from the terms of the NDA. For example, information already known, information independently developed, or information publicly available. Without those carve-outs, you've got a mess. Now let's talk about something serious. We're talking about a clause that makes many contracts professionals nervous every time they see it. That is the personal liability clauses. Some NDAs try to make you personally responsible, not your company, but you. Which means you personally, not your company, could face the damages. Now, that's a very serious obligation, and it should never be accepted casually. To me, this is one of the major problems because most people signing the NDAs don't have a legal defense team, and they don't even realize what they've agreed to. So let's move on now to talk about where NDAs actually matter the most. Proposal development. Because the proposal development phase is where companies share lots of data and information. And at this point in the game, you're dealing with technical solutions, approaches to pricing, and strategies for capturing the win. This is real intellectual property, which means NDAs must be carefully structured. Because if the language is sloppy, if your NDA is weak, then you're exposed. And if it's too broad, it's unenforceable. And in either of those situations, companies risk exposure or even losing their most valuable intellectual property. This is where precision really matters. Now let's talk about something else that causes constant confusion. Mutual NDAs. On the surface, a mutual NDA sounds very fair. Both sides protect each other. But here's the problem. They often become very bloated, trying to cover every scenario. And when that happens, it becomes harder to enforce because the broader the scope, the harder it becomes to prove violations. Because broad equal vague and vague equal weak. To make a point, let me read you one of those types of clauses. The receiving party shall not disclose any information received through verbal, written, or interpretive gesture. Interpretive gesture. So now charades is legally risky? Somewhere a lawyer wrote that and said, nailed it. The rest of us, we're still shaking our heads. I've already crossed that sentence out. Okay, so now let's move to the question people ask all the time. Are NDAs actually enforceable? Yes. NDAs are absolutely enforceable. But courts look for reasonableness. That means reasonable scope, reasonable duration, clear and reasonable definitions of what confidential information actually is. If your NDA tries to control everything forever, courts will push back. So now I want to discuss the risk associated with NDAs. The biggest risk isn't always lawsuits. Most often, the biggest risk is the business consequences. It's your reputation. In government contracting, companies that mishandle confidential information quickly develop a reputation. And in this world, reputations spread very fast. If you mishandle proprietary information, people remember, and they stop working with you. So let's answer the practical question. Should you sign an NDA? Yes, usually, but only after asking questions, like what information is protected, how long is the obligation to protect it, and what are the exceptions, and what happens if something goes wrong. All right, time for my final thoughts. NDAs are tools. They're not magic spells. They protect real secrets, but they shouldn't attempt to control every conversation you've ever had. Because when NDAs become performative, they stop serving their purpose. Here's your takeaway. Read the NDA, understand your obligations, and if the language sounds like it was written to govern the entire universe, you might want to ask a few more questions. And if you want to actually understand what you're looking at, add the book, Become a Government Contracting Wizard, Mastering NDAs for Government Contractors, to your Amazon shopping cart. Because this stuff matters more than people think. Thanks for joining me for this episode of the GovCon Show. Until next time, redline those agreements aggressively. Make sure you understand what you're signing. And never sign anything that you don't understand. Talk to you soon.
If today's episode sounded a little too familiar, that's probably a sign. Until next time, keep your files tight, your logic tighter. Remember, if your compliance approach is built on checking boxes, you're building risk. We'll see you next time on the GovCon Show.
This broadcast has been cleared for public release, but just barely.